Good afternoon, once again for some of you, and welcome for those of you who are joining us for this second panel discussion. Your Excellencies, distinguished candidates, ladies and gentlemen, it's my esteemed honor to welcome you to this second panel discussion organized by the Coalition for the International Criminal Court with the candidates for ICC judge set for the elections that are set to take place in December of this year in New York. Once again, my name is Kirsten Meerschaert, and I am the Director of Programs with the Coalition for the International Criminal Court, which is a network of more than 2,500 non-governmental organizations in 150 countries, working in partnership to ensure that the court is fair, effective, and independent, to make justice both visible and universal, to strengthen international cooperation with the International Criminal Court, and to advance stronger national laws that deliver justice to victims of genocide, war crimes, and crimes against humanity. I would once again like to express our deep appreciation to the host state of the Netherlands for hosting today's discussions. And thank you to Ambassador van Ijssel and all of the colleagues here at the Ministry of Foreign Affairs who have helped arrange for us to be here this afternoon. I'd also like to thank each of the candidates joining us for this second panel. These panel discussions aim to enable the nominees to expand on their respective qualifications and expertise, as well as to promote more fully informed decision-making on the parts of states when they come together at the Assembly meeting in December to elect 6 judges. There is English, French interpretation available for those of you who require it. And once again, I would like to thank the interpreters in advance for their efforts during this panel session. A point of logistics for those of you joining us for the first time: should you wish to leave the building at any point, you must return your badge. And then if you wish to come back into the ministry, you will need to go through the registration process again, by which I mean you will need to collect a new badge downstairs. Today's event is being recorded and live streamed. And for those who might be joining in on this conversation from afar, you can join in on the discussion via Twitter using our Twitter handle, which is @NGOs4Justice. And we are using the hashtags #ICCelections and #ElectTheBest. I would like to emphasize that while we are here in this impressive setting, this event is an independent event organized by the Coalition for the International Criminal Court. It is part of a long-standing and comprehensive campaign that the Coalition has conducted with regard to elections to the International Criminal Court since 2003, because we firmly believe that the only way that the court will actually realize its ambition of being a fair, independent, and effective international justice mechanism is if its chambers are composed of only the most highly qualified judges. Since those first elections back in 2003, the Coalition has conducted this campaign in the aim of helping to promote and publicize and raise awareness about the elections and the individual candidates, including by preparing detailed fact sheets, memos on the nominations and elections processes. This December, we will have 6 new judges to be elected to the ICC bench. And therefore, once again, we hope that today's panel discussions will provide an opportunity for all of you in the audience here in The Hague, but also watching from a distance, to learn more about the candidates' individual qualifications, experience, and expectations for international justice. In addition to organizing such public seminars, the Coalition has also asked each of the nominees to complete a questionnaire that also seeks to provide additional information about their qualifications. You can read the candidates' responses to the questionnaires on our website at www.coalitionfortheicc.org. I should note that the Coalition as a whole does not endorse nor oppose individual candidates, but we advocate merely for the integrity of the nomination and election procedures. As such, the Coalition strongly opposes reciprocal political agreements, otherwise known as vote trading, in ICC elections. In a moment, I will ask the candidates to take a few minutes to introduce themselves to the audience, and then I will open up the floor to questions and answers. I would ask that when we move to the Q&A portion, that those of you who are wishing to take the floor to pose a question to the candidates, please do so in a way that addresses all of the candidates in the panel, so that each candidate will have the time to respond to your question. And I would also ask you to refrain from making any statements or prefacing your question with any comments. Finally, I would exhort you to also refrain from asking the candidates any questions in relation to ongoing preliminary examinations, cases, investigations, or situations either currently before the court or potentially before the court in the near future. That being said, as I prefaced, I would like to give the floor now to our candidates to provide a bit of an introduction to themselves. Two of our panelists for this session may be speaking in French. So for those of you who require the interpretation, please have your headphones at hand, as it might mix up a bit here between English and French. Donc, en première, on a Monsieur Vukoje.
So first we will listen to Mr. Vukoje. Please introduce yourself.
Monsieur Vukoje, vous avez...
Mr. Vukoje, please, you may take the floor.
Bonjour.
Good morning.
English for this moment, for introduction my speech. Dear colleagues, thank you very much for inviting me to participate in this coalitions panel today in The Hague. I am honored by the official nomination for judicial appointment at the International Criminal Court, especially in challenging times of the court, and truly welcome the opportunity to share my motivation and experience in a commonly public, transparent, and merit-based selection process. As announced, my name is Dragomir Vukoje. Currently, I am the judge of the Appeals Division of the Court of Bosnia and Herzegovina. I believe that my professional and academic background and experience qualify me for the position at the ICC. I have been criminal judge at various levels in Bosnia and Herzegovina for the past 25 years, including 13 years at the Appeal Division of the War Crimes section of my court. In the given capacity, I have decided in 75 most complex cases, atrocity, crimes, allegations, and specific modes of liability under ICL. Following completion of doctorate in ICL, I became professor of criminal law and procedure, member of the High Judicial and Prosecutorial Council of Bosnia and Herzegovina, a body that appoints judges and prosecutors in the country, and of the European Commission for the Efficiency of Justice of the Council of Europe. I am most proud of my work at the War Crimes Chamber of my court, firstly established as an internationalized and today a fully national judicial institution that has, among others, adjudicate war crimes cases transferred from ICTY. This court applies domestic criminal law that is aligned with international criminal, humanitarian, and human rights law. When it comes to definitions of genocide, crimes against humanity, and war crimes, these provisions are fully based on respective definitions contained in Articles 5 to 8 of the Rome Statute. In addition, the model of criminal procedure used in BIH represents hybrid mixture of elements of Romano-Germanic and Anglo-American tradition. tradition involving, but not limited to admission and negotiation on guilt, adversarial nature of proceeding, etc. In delivering justice for worse crimes committed in BIH, I have enjoyed working with the international colleagues, peer judges, prosecutors and legal associates from all over the world, from the USA to Western Europe's countries, from Australia to the UK. This experience allowed me to extend my legal horizons and improve my skills while contributing to the peace-building process in my country. From my personal experience as a war crime judge, I do believe that national jurisdiction, for many reasons, should be forum for the adjudication of atrocity crime cases, while international court should complement it in case of need. It's not just the question of ability of international court to adjudicate all cases, but it is also the question of availability of justice models in the vicinity of places where the crimes took place and competence of local judicial actors. Therefore, the present model of relationship between national courts and the ICC based on complementarity, if used correctly, can contribute to substantial justice. In my view, several key challenges, for example, the legitimacy or the question of courts' credibility, etc., reflect the contemporary work of the ICC, and they are widely discussed. But and because that I am not going to speak about it, I will try as a future judge, I hope, resolve some of this situation. However, when the situation is opened before the court, its cases and case law can serve as compass to able national jurisdiction. Complementarity is a two-way road, and ICC should limit itself, as it is provided in the preamble of the Rome Statute, to the most complex forms of international crimes under its subject matter jurisdiction. As much the result is important, so is the path toward justice. In that regard, I would welcome the opportunity to utilize my practical experience within the ICC framework. In conclusion, I am enthusiastic with the period ahead of us. I am thankful for the opportunity to be considered as candidate for the judge of the ICC, which is at the same time both an honor and professional challenge. According to my experience, in order to achieve justice, theory is also important, but in my mind, justice can be achieved only in the courtroom. Thank you very much for your attention.
Thank you, Mr. Vukoje. Ms. Akane.
Thank you, Madam Moderator. Excellencies, distinguished representative of the relevant organizations, I thank the Coalition for the International Criminal Court for organizing this event. I'm Tomoko Akane, Ambassador for International Judicial Cooperation and the Public Prosecutor for the Supreme Public Prosecutor's Office of Japan. I wish to serve as a judge for the International Criminal Court, and it comes from the sense of mission as a long-time public prosecutor of Japan. In other words, I wish to join its endeavor to put an end to impunity of the perpetrators who commit the most serious crimes of concern to the international community and to bring justice to such criminals and to ease the pain of the victims, and eventually to contribute to the prevention of such crimes. There are two main reasons. First, I believe I can definitely contribute to the work of the ICC based on my work experience as a public prosecutor and government attorney in Japan for over 35 years. In dealing with various kinds of criminal cases, I have applied my expertise on criminal law and procedures, not only in investigation, but also in the court process. With my expertise in the work of prosecutions and for the court, I am also confident that I am able to ease victims' pain incurred by the crime during the proceedings. Second, I wish to contribute through the work as a judge of the ICC to bring more justices to the international community based on my many years of experience in the field of international cooperation. Over the years, I have been involved in the international technical assistance, technical legal assistance, and capacity building for criminal justice practitioners, such as public prosecutors and judges in developing countries through the activities of the Asia and Far East Institute for the Prevention of Crime and the Treatment of Offenders affiliated with the United Nations, called UNAFE and known to the global community, and of the Research and Training Institute of the Ministry of Japan, Ministry of Justice, Japan. Sorry. Through my experience, I came to learn that criminal justice practitioners in many countries work very hard to develop their own criminal justice system, to fight against heinous crimes, and to end impunity. But there are a lot of hindrances to achieving such goals. I also learned that the rule of law is crucial for the realization of criminal justice, but that is not easy to achieve it in many parts of the world. The work of the ICC, which requires international cooperation by the state parties, would definitely assist such endeavors in the respective countries through their dedicated efforts, and thus I wish to be a member who could contribute to the work of the ICC. I'd like to work every country with the aim of the end of the impunity. Thank you very much.
Thank you. Madame Alapini-Gansou, je vous donne la parole maintenant.
Ms. Alapini-Gansou, you have the floor. Thank you very much, Ms. Moderator, to give me the floor and to enable me to express myself. Before I introduce myself, I would like to pay homage to the people who are listening, the representatives of civil society and the diplomats. I would also like to acknowledge the African Union and the economic community of the Western African states, that they have endorsed my nomination for the post of judge at the International Criminal Court. As representative from Benin, I've always had the ambition to contribute to the work of the International Criminal Court. With my professional career, this project is a good one and will enable me to contribute to fight against impunity and promote justice in the world. I am a lawyer at the bar in Benin in civil law, and I have postgraduate degree and master's in judiciary careers, a university diploma in the area of common law, and also diplomas for humanitarian law, human rights law, and women's rights law. I've studied at the University of Strasbourg and also in Rome. As a lawyer, as teacher of criminal law and legal proceedings in my country, I have been the author of different documents in the field of human rights, humanitarian rights, and female rights. International cooperation is important, and I'm aware of criminal law proceedings, and at this day I can say I have 31 years of experience at the bar. I have also worked for Africa Sans Frontières, so Africa Without Borders, based in Belgium, and I have also contributed to the work in Rwanda after genocide that took place. In my country, I have obtained anti-constitutionality of the civil codes that considered the position of the woman to be inferior. I've also pleaded in the file Aide Ouedraogo against Burkina Faso, to mention just one case. I have also been a member of other working groups in my country, but also working for the Chamber of Commerce and Industry and the Association of Interprofessional Relationships. I'm also a teacher in proceedings for the International Center of Training for French-speaking lawyers, and I'm a lawyer also on the list of the ICC. In the field of international law and human rights law, I will leave the post I am occupying after 12 years of experience. After 12 years, I have the privilege of having been elected president of this particular commission. And I've also had the privilege to have been elected as special rapporteur for the African Union. And I have taken part in the Commission of Promotion of Human Rights, and in that position I have visited 45 countries in the African continent. The mission of the African Commission of Human and People's Rights has a specific purpose. And I can say that I am quite capable of occupying the post of judge at the ICC, because we deal with violations against human rights committed by states, by victims, and non-governmental organizations. And we have already adjudicated 3 cases on the African continent. To strengthen this mission of protection of human rights, the protocol that has founded the Coalition for Human and People's Rights has ensured a parity between this coalition and the African Court. And as a president of the African Court in the period 2009-2011, I installed this complementarity. And to this day, these 2 bodies have 9 meetings since 2009. So these institutions work to enhance this complementarity and improve their action. So nowadays, there are more than 700 cases of violation against human rights. And the court has also been asked to adjudicate on their acceptability and fund of these cases. We also take count of other systems of law, the United Nations system and the Commission, based on Articles 60 and 61 of the African Charter of Human Rights, but also international law and other charters that are a source of inspiration for their work. As a member of the Communication Department, for the African Commission of Human and People's Rights, we would like to be able to work in a quicker way in the communications and investigations. I have received different prizes and awards that show that I've always been quite motivated and committed to promote human rights. Regarding associative movements, I contribute to the WINDAF movements, Women for Education, Women for Development, the International Federation of Female Lawyers, and the International Bar as well. In that behalf, I have contributed to the election of the president in our country. I'm also ambassador for the ICC in our country, and I've also contributed to adapting the legislative framework in our country to the Charter. I've contributed to different exchanges and meetings and seminars on high level, and I have contributed to promote the adoption of laws that will improve the position of women and vulnerable people. So to promote the rights of women and vulnerable people in my country, I have already adjudicated in more than 250 cases and contributed to reparations and settlement. So in 2016, thanks to Mrs. Catherine Samba-Pensta, I was elected second vice president of the Pan-African Observatory for Female Leadership in French-speaking Africa. Now, regarding special expertise, in a few words, I can say that I am judge at the Permanent Arbitration Court in The Hague, and that for the United Nations, I was nominated to be a member of the investigation committee regarding violences committed at the elections in Ivory Coast in 2011. I also was a member of the investigation committee in Burundi, and currently we are presenting our report of conclusions in Geneva. Now, finally, I would like to say that I'm an expert member of UNAIDS regarding human rights and the HIV virus. I have also been member of a jury in fictional proceedings at the request of the Center of Pretoria in Southern Africa. So my ambition is to be a judge in the ICC with the full conviction that my expertise will contribute to improve criminal justice on the international level. But I would also like to be able to adjudicate, have the law prevail. And at the ICC, it is important to create rights, justice, and promote justice. This is what I can say as an introduction, and I'm open to any questions you may have. Thank you for your attention.
Merci, Madame. Ms. Ibanez.
Thank you very much, Kristen. Your Excellencies, the ambassadors and the representatives of the states, and also the representatives of the civil society, ladies and gentlemen. I would like to say thank you to the Coalition for the International Criminal Court for having invited me to participate in this event. And also I would like to congratulate to my fellow nominees for being here to discuss or to express our ideas about International Criminal Court and international criminal justice. My name is Luz del Carmen Ibáñez Carranza, a very long name, but Luz Ibáñez or Luz Ibanez is good. I am a senior national prosecutor in my country. I have been a prosecutor for more than 30 years, and in the last 14 years, I have been prosecuting cases in a special manner, cases of terrorism, crimes against humanity, grave violations of human rights. All of those crimes, most of them, that come from the non-international armed conflict that went through in Peru between 1980 to 2000. Before of that, I have been an investigation prosecutor in the Office of the General Prosecutor of Peru. And I have been in charge of investigations of crimes of bribery and grave corruption against the high officials of my country, such as the former President Fujimori. In addition, I am the national coordinator of the 17 prosecution agencies of the specialized system in my country. The systems that is in charge of the same crimes of terrorism, crimes against humanity, and grave violations of human rights, such as tortures, extrajudicial executions, enforced disappearances, crimes, sexual crimes, and gender-based crimes, and the cases of the child soldiers, and so forth. In both capacities, I have been working for this last 14 years very hard in those issues over those international crimes that are the same crimes that are under the jurisdiction of the International Criminal Court. In my capacity of prosecutor, I have prosecuted the cases of the highest leaders in my country, the highest leaders of the terrorist organizations, such as the case, the mega trial against the leader and the leaders and the persons of the leadership group of this terrorist organization, Shining Path. The name of the highest leader is Abimael Guzman. Shining Path has been the most lethal and bloody organization in the history of Peru. This organization is responsible of more than 40,000 victims, according the final report of the Truth and Reconciliation Commission of my country. I was the prosecutor that sent Abimael Guzman and all the leader group to the very high sentences in a mega trial followed between 2005 and 2006. Abimael Guzman and the principal leaders of this terrorist group were convicted to a life imprisonment, and the others were convicted to a very high sentences. The charges were terrorist attacks, such as murders, destruction of the public and private property, massacres of one town, the Andinian town of Lucanamarca, and there were about 500 victims from these crimes. In the other hand, this has been a very historic case and historic sentences in Peru. In the other hand, I have been prosecuting cases of grave violations of human rights and landmark cases, such as the case named Cabitos. Cabitos is a case about massive tortures, enforced disappearances, extrajudicial executions that were committed in the headquarters of, in a military headquarters placed in the Andinian town of Ayacucho in Peru, where were perpetrated those massive tortures, enforced disappearances, and extrajudicial executions. There were 109 victims, and there were 10 persons accused, all of them high political and military officials. And they were charged with 509 counts. All my cases are complex, with a very voluminous evidence, because a high quantity of documents to disclose, always dealing with protective witnesses, and with a lot of juridical challenges and issues on reparation. To success in these efforts, I have always been integrating the international law with the domestic criminal law. As a national coordinator, all my work has been not only to supervise and monitor the work, the trials and the investigations of the 17 prosecution agencies, but to enhance the work with the victims, with emphasis in reparations, and in a special manner in the cases of sexual and gender-based crimes, and in the cases of child soldiers, and the cases of enforced disappearances. Finding always very creative responses on reparations, moreover than economic compensations. All of this extensive work have prepared me to face the big challenges of being a judge of the International Criminal Court. And I would like to bring the experience of Peru to the ICC and my personal and professional experience to contribute to the international criminal justice and to continue working on the same crimes, but now at international level. Also, I want to contribute to the fight against impunity and to the prevention of the atrocities and the heinous crimes that affect the international community as a whole. After all of these years of experience, I feel I am prepared to do it. Besides, I am a university professor. I have been teaching criminal law, procedural law, and human rights in a public university for more than 21 years. I also hold a criminal law master and a Doctor of Law degree. So I think I have the academic skills that the post of a judge of International Criminal Court would entail. I would like to be a part of the tremendous effort that the ICC represents in the fight against impunity, that it's also my personal commitment. I have served my country for more than 30 years with loyalty. Now, I would like to put myself in the service of the world and at the service of the world peace. Thank you very much.
Thank you, Ms. Ibáñez. It's my pleasure now to open up the floor for questions from the audience here in The Hague, or for those of you following us on social media. Please just raise your hand if you're here in the room, and if you're not, well, we'll get your questions through Twitter, I assume. I'll just remind those who wish to take the floor to please pose questions that are addressed to all of the candidates so that they can each address the question equally. I see someone in the back here. Thank you.
Thank you very much. Thank you to all of you for being here and for engaging with us, a diverse audience of states and civil society. I would like to discuss with you one of the challenges of the court. Hearings before the court have been suffering from a lack of public sessions. It's been an issue at the International Criminal Court for a number of years, both hindering access by the public to the work of the court, but also to some extent challenging the rights of the accused to a public hearing. It's particularly relevant in the context of the ICC being so far from affected communities. My question is, could you tell us, based on your experience, how to address the issues contained in the lack of transparency and public access to hearings, and what role for the judges in ensuring transparency, both as an element of fairness and access to justice. Thank you.
Thank you very much. So the question pertains to sessions of ICC proceedings taking place in a closed format. The questioner would like to your reflections on the role of judges as to how also these sessions may impact the rights of the accused and affected communities, and how you may think judges would have a role in this issue. Ms. Ibáñez, if I can start with you.
Thank you very much. This issue about how to address transparency and the access of the hearings are part of the problem of the positive complementarity and accessibility that the court must face. I think that as a judge of International Criminal Court, we have the big opportunity to work on it. In Peru, all the cases are in those issues, terrorism and crimes against humanity and grave violations of human rights, all are public. And not only because the people that goes into the courtroom, but because the media is allowed to be there, and through the television and the radio spaces, there are a lot of people, not only practitioners, not only judges, not only prosecutors, can have the access to the hearings, but everyone. I think the transparency is the best warranty that any court must observe. So I think that as a judge, we can work a lot over this issue, and I have also a plan. Thank you very much.
Thank you, Ms. Ibáñez. Madame Alapini-Gansou.
Merci.
Thank you. Thank you. I thank you for this question. In order to answer your concern, my colleague spoke earlier of the need for positive complementarity. I will carry on from there and say that it's true that to this day, we have identified lots of challenges for the ICC, challenges which I will call classical challenges, which relate to the efficiency of the ICC, the cooperation between the ICC and other interested parties, the question of the universality. But well, without going into the detail of the different challenges which are showing up now, but to come back to this classical challenge, I would say that the question that has been raised pertains especially to the efficiency of the ICC. How can we ensure that the ICC is efficient? And efficient from the point of view of the rights of the parties, both the accused and the victims. And here, when we speak of the fact that the hearings of the ICC have suffered from a lack of public audiences, public hearings, I would say that this is something that comes up very often when I speak with people about the ICC. All of this relates to the access to the ICC. I think that the Rome Statute makes it possible for the ICC to move closer to the victims. I think we have some examples here that can help the ICC in this. For instance, when you look at the Democratic Republic of Congo, how together with actors of civil society, they were able to set up mobile courts. And I think that this really helped the population. It made it possible for justice to move towards the population. And I think that maybe this is what is lacking a little bit for the ICC. The ICC is really very far from the victims. When I take one situation in which the ICC has to meet a certain number of victims, maybe it would be better for the ICC to delocalize these sessions in order to... So we'd have to see what we have to do to delocalize the ICC. Other jurisdictions at a lower level have been able to get closer to the involved parties, to the different political parties, to the civil population, and so forth. I would like to mention here the Human Rights Court of ECOWAS. When they wanted to work on the very serious problem of slavery, they delocalized one of the hearings. They left Abuja. And I think that this is an example which was heard all around the world and which could inspire us, because this is a true challenge. I think that if you work in this manner, then the ICC can also get closer to the proof, closer to the truth, because the truth can speak from the field and the victims can be heard and seen. So if the International Criminal Court could move towards the population, move towards the victims, we would really solve a lot of problems. As we say in French, you could really kill a bird with two birds with a stone. So I think it's very important that the ICC think in this direction. If I were to be elected, I could work. I could work on organizing hearings outside of the ICC.
Madame Alapini-Gansou, Ms. Akane.
Thank you for your question. I understand your question is related to the transparency and fairness of the court procedure and public hearing. In my view and my observation so far is that the court itself has made a lot of efforts to be transparent and fair court procedures. For example, they air all the hearings in the courtroom by the media, by the internet media, and I can observe the hearings from Japan, even from Japan, and also you can see all the judgment or important decisions through the internet too. And also there are a lot of researches and presentations or something related to the judgment and the court hearing. A lot of opinions are raised in various kind of places. So, of course, there might be some room to improve. If I am elected, I try to make the ICC's work more transparency and fair with cooperation of the civil society and other state parties. Thank you.
Thank you, Ms. Akane. Mr. Vukoje, à vous
Si.
la parole.
L'audience.
Yes, the public hearing, it is a rule under international law, but also under national law. It is a fundamental principle. However, there are some exceptions in terms of the respect of this principle. One of the most important exceptions with regard to this is the respect of privacy in the interest of the victims. And this is a reason why there are some situations which are valid. This is to say that the interests of the victims should come first. However, these are some very rare situations in the normal procedure. So respecting this principle, the principle of the public audience, is again an important rule with some exceptions. In my practice, when I was conducting a trial in my court, we had a section dedicated to the protection of the witnesses, the protected witnesses, the vulnerable witnesses, and in particular the women and children. Protecting their interest was primordial. And so I think that there could be similar exceptions at the ICC in terms of the procedure. Now, of course, in terms of the participation of the victims, well, in our cases, this is not as important as the participation which has been foreseen under the Rome Statute. As you know very well, the Rome Statute lays a great emphasis on this.
Merci, Mr. Vukoje.
Thank you, Mr. Vukoje.
If you do, you can just raise your hand. Yes, over here, please.
In which case, I might just repeat the question I put this morning, because then we get answers from more candidates on the same question. I'm Thomas Verfus. I'm here for Journalists for Justice. As a judge at the ICC, you will not only deal with trial proceedings, pre-trial investigations and appeals. Apart from your judicial work, you are also part of a collective effort to improve the Rome Statute system, which is still a relatively young system. You have formal roles in the system, like when you deliberate in the plenary to about amendments of the rules of procedure and evidence that might be put before the Assembly of States Parties. You can also informally participate in the debates amongst states and academics about possible amendments or desirable amendments to the Rome Statute. As you are candidates to this high judicial office, I assume you have been observing the work of the past court, during the past years. I wonder if you have been struck during your observations by things you think might have to be changed and which you might propose in different ways, either in the plenary of the judges or by way of proposals to amend the Rome Statute. I'm thinking of two things in particular which you might wish to address as an example. Firstly, the rules for contempt. If we look at the ICC, it is only the Office of the Prosecutor which can investigate and prosecute offences against the administration of justice, as they are called in the Rome Statute system. That is the case even if the potential suspect is a staff member of the Office of the Prosecutor. The drafters of the Rome Statute had before themselves models of other international courts, or there are various possibilities at the disposal of the judges according to the circumstances. At the ICTY, it can either be the OTP that prosecutes, or there may be an independent amicus curiae prosecutor, or it may be the trial chamber itself that investigates. So I wonder what your ideas are about the exclusive competence of the OTP for Article 70 proceedings. A second point you might address is the mechanisms and checks and balances when the OTP does choose not to prosecute, or does not even give any statement as to which point its investigations have proceeded. In national systems, there are various mechanisms, checks and balances, like here in the Netherlands. Victims and other interested parties can ask an appeals court to order the OTP to investigate and prosecute. In Germany, it would be a crime for a prosecutor not to prosecute if there are indications that crimes have been committed. In the ICC system, there is no such mechanism. So do you think it is a lacuna? And can you think of remedies that might be provided? Thank you.
Thank you. So if I could sum up that question. What, as candidate and potential judge before the ICC, do you think you might contribute in terms of the further development of the Rome Statute system? I think, as I prefaced earlier, I invite the candidates to forego the question related to observations of cases or investigations that have already taken place and what they might change because of the impact that could have further down the line were they to be appointed to the bench in terms of having to potentially recuse themselves. That being said, the second part of the question related to contempt cases before the court and the fact that that currently seems to be the sole prerogative of the Office of the Prosecutor. And the second point of the question related to what to do when the Office of the Prosecutor declines, for example, to request the opening of a formal investigation, referencing that some national systems do allow for alternative means of, let's say, obliging an investigation to be opened. So perhaps I can ask Ms. Akane to address this question first. Thank you.
Thank you. Thank you for your question. Since I am a candidate for the judge, so my observation is from the point of view of the future judge of the ICC. But in fact, as a judge, every judge should have the interest for the further development of the Rome Statute system in terms of the improvement of the rule of the procedure and evidence, for example, and better and more efficient procedure of the court process, or shorten the term of the prosecution and judgment. That might be raised from the judges also. So, of course, judges have made a tremendous effort to make changes within their capacity, but sometimes it is necessary to amend the rules and also Rome Statute. In such case, firstly, judges may discuss internally and finally may decide in the plenary of the judges and through the mechanism of the presidency or other to raise the question to the ASP. And with a good relationship with ASP, sometimes the interest is not the same, but also the aim must be the same for the development of the ICC system. And without appropriate funding, the judges' trial to change or improving the system cannot be achieved. So with good relationship with ASP and cooperation with the ASP, judges should improve the system itself. And about the oversight mechanism, and in the case of the non-prosecution by the prosecutor, as a judge, the judges must respect the final decision of the prosecutor not to prosecute, because prosecutor has independency apart from the judge's duties. But of course, there might be some limitation and some oversight mechanism is necessary to see the prosecutor's work. So learning from the state parties' systems in the world, maybe ASP will develop the further mechanism to not to infringe the rights of the prosecutor, but to promote more efficient and credible work of the prosecutor. That might be some room to discuss. Thank you very much.
Thank you, Ms. Akane. Ms. Ibáñez, can I ask you to address the question? Thank you.
There are several questions in one question. I would start by saying that the first question about improving of Rome Statute as candidate. This issue has to be with universality. Universality is also a very big challenge that the International Criminal Court has been facing since the beginning. Of course, there are a significant number of states that until now are not part of the Rome Statute and that have not included in their national legislation the core crimes of Rome Statute. Therefore, they do not prosecute them. What can we do as judges? I think that to fight these challenges, the judges can do a lot. I think it's necessary that, for example, the decisions of the court, of the judges, may reflect fairness and effectivity in order to be perceived by non-signatory countries as an efficient court that works to ensure the prevention of core crimes. I think the judges have a special duty and special onus on it. Expeditious trials and fair trials will do and will work a lot for universality. I think judges, if I am elected, as I told you before, I have a designated plan of action to do it. The rules to prosecute the crimes of the Article 17. Of course, the prosecutor office has the obligation to prosecute it. I think it's very necessary to enhance the effectiveness of the International Criminal Court also. And in the last issue about the mechanism of oversight, the mechanisms for check and balances for the work of the OTP. I think I'm agreeing. It's necessary. It's necessary, this mechanism. For now, according to the provisions of the Rome Statute, the provisions of Article 15, of course, when the prosecutor concludes that there's no reasonable basis to continue with an investigation, it will finish there, but not precludes the obligation of the prosecutor. Because if further there is more evidence or new information, also the prosecutor can open again the same case. It's necessary, I told you, an oversight mechanism because in the cases of grave violations of human rights, as are most of the cases of the court, in America, in the Convention on Human Rights, Inter-American Convention on Human Rights, we have an article that provides that in those cases, there is a special right for the victims to know the truth. And this right is not only for the victims, it's the right, in Peru, for example, in our national jurisdiction, is the right of the society. And I will say that it is also a right of the international community to know the truth. And I think that this mechanism, this oversight mechanism can work in this issue. I think it's very necessary, I agree, and as a judge, maybe we can, in an informal way, to work to do this, or maybe we can work in more future amendments of the rules of procedure and so forth. Thank you very much.
Thank you, Ms. Ibáñez. Monsieur Vukoje, la même question.
Find the answer to that question is not easy. On the one hand, we have the victim's rights to ask for justice. The prosecutor's role to engage proceedings and honor the rights of the victim is important, but the role of the courts is also to guarantee a fair trial for each individual. And to ensure that, it is important to maybe amend the role as it is described in the Roman statutes, the role ascribed to each actor in the judiciary proceedings. In my view, the statute has some parts missing. I think there's a mixture of the capacities. On the one hand side, the prosecutor, and on the other hand side, the courts. So this should be improved or perfected. The different clauses of the Roman statute should be fine-tuned.
La préoccupation de Monsieur
The concern my colleague has just expressed is important. I believe he has expressed many different concerns. The first that was mentioned relates to the fact that a judge at the ICC should fulfill its role, but also look to ensure operational procedures. I'll try to explain this. At the International Criminal Court, we know this is an institution based on two pillars, the legal pillar and the operational pillar. And as has already been said, it does happen that judges at the ICC work both on the legal aspects, but also on seeing how they collaborate with other actors, like, for example, the assembly of state parties, or in other activities of the court, there may be issues arising, like budgetary problems and such. This will require amendments of the rules and regulations. So a judge does not only have his adjudicating work, but the ICC also exists because the assembly of state parties want them there, and they need to collaborate with this pillar in order to become more efficient. Such work requires a lot of delicacy and diplomacy, but also flair. You need to find the right strategies and find how the judges can cope with the problems. I believe that the ICC is a project that is ongoing. We shouldn't want to go too quickly. You simply need to start on time and work and continuously improve. So if you take the example of other courts, for example, the International Court of Justice, well, the International Court of Justice has also had difficult times, and still it is a working court. So I believe that the ICC can be founded on what's already created, both on the international field for human rights and also based on regional systems, like the system of the Criminal Court for ex-Yugoslavia, what's been done there, and also the court for Rwanda. But there's also other mechanisms, inter-American mechanisms, for example. There's an inter-American court and special commissions and committees, and we need to build on that and go forward. So this is a global approach. The other topic you have mentioned related to a situation according to which there is an issue of contempt. And you ask, what should you do in such a situation? Because the ICC gives the role to the prosecutor to engage proceedings. And so nowadays, not only should we render justice, but we also need flair and initiative to create justice. And the ICC needs to evolve and develop in the course of time. And in the day-to-day operations of the ICC, we need to find a new structure and build on that. So yes, in a way, we have information according to which we should combine all the systems of justice that exist in the world, because we need to give coherent and consistent decisions when we adjudicate. So everyone can give a national example. In my country, when judges have to deal with a case of contempt, it's simply an incident and there's a certain way to operate. You don't ask for the prosecutor, the judges can immediately act on that. But at the ICC, I believe that there should be independent control mechanisms through which you can see what should happen and how we should act in such a case. Now, the last concern related to the fact that it might happen that a prosecutor decides to refrain from engaging procedures. Sometimes you can find a solution. In the past experience of the ICC, I will not mention any specific rendered decisions, but as my colleague from Bosnia has already indicated, when the prosecutor decides to refrain from prosecuting, you have to deal with the rights of the victims. In the Roman statutes and in the rules and procedures, it is indicated that victims are allowed to ask the judge to make a decision, and then we can ask the prosecutor to engage procedures, and then the collegial chamber can render a decision. But it is an issue, and each and every judge should consider how it is important to call on new mechanisms to mitigate such a situation. So either one of the parties should be able to go in appeal. The judge should be able to do that. The victims, the accused should also be able to go in appeal, even someone who's not yet on trial by the ICC. This is how I would react to your questions and concerns.
Alors, y a-t-il d'autres questions dans l'audience ou à travers la média sociale? Ah oui.
Bonjour. My name is Nikos Archididis. I am the deputy of the Embassy of Cyprus here in The Hague. I would like to congratulate the coalition for the ICC and all the candidates for this very useful and interesting debate. The upcoming Assembly of State Parties, beyond the election of 6 very qualified judges, will have to deal with other significant issues, such as the activation of the Kampala amendments, including on the crime of aggression. As jurist, I would like to ask you how essential you regard the activation of the crime of aggression to complete the Rome and to complete and further develop the Rome Statute system. Thank you.
Thank you very much for this question. So if I can resume again, in addition to the elections taking place at this year's Assembly of States Parties meeting, there'll be several other thematic discussions, including around the activation of the amendment in relation to crime of aggression. As this potentially could touch upon future investigations, cases, and preliminary examinations before the court, I do want to leave the candidates some room to treat this in a more general terms, their own opinions about the future activation of this amendment and its implications. So, cette fois-ci, Madame Alapini-Gansou, si vous pouvez commencer.
Mrs. You can start. Thank you very much. On the activation of the crime of aggression, what I can answer immediately is that the question of aggression is not a new question. It's actually quite an old question, but that is still very pertinent. The other thing I wanted to say with regard to the crime of aggression, and that the conference of Kampala and already during the work aiming for the adoption of the Statute of Rome, this is a question that was already brought up, but which was deferred, maybe for political reasons. But anyway, it was postponed. And so necessarily, at a certain point, this crime of aggression needs to be included in the crimes and for which the ICC has authority. So during the conference of Kampala, that is one of the questions that was treated, and the crime of aggression must be included in the crimes that fall under the authority of the ICC. Now we're speaking about the activation of this crime. A judge is bound by the text. If the Statute of Rome says from now on that the crime of aggression is part of the crimes that fall under the authority of the Statute of Rome, well, then a judge must find the moral, intellectual means to treat these questions. The crime of aggression is a crime like the other crimes. It is a very important crime, for instance, in the framework of genocide, of the war crimes. And so if the crime of aggression is included in the Rome Statute, all judges must be able to treat this question when they're called upon to do it. Thank you. Mrs. Alapini-Gansou. Mr. Vukoje. Yes, it is true. The state parties have worked hard to improve things and to include aggression. But the crime of aggression adopted in Kampala, this has been a great chance, as my colleague has just said, to criminalize this action. However, the problem remains of making this a reality. This is our task for the future, but this, however, is the goal. Thank you. Thank you, Mr. Vukoje. Mrs. Ibanez, you have the floor.
I will start for saying that this year the Assembly of States Parties will deal with this issue in the upcoming Assembly of December. The states are going to vote on whether the crime of aggression enters into force or not. In the amendments of Kampala, the crime of aggression have been regulated. Now, there is a definition of what a crime of aggression is. It's in Article 8 bis. Who can commit this kind of crimes? And what is the role of the Security Council? The exercise of the jurisdiction over the crime of aggression also is regulated in this Article 15 bis of the Rome Statute. It's interesting to recognize there that in this provision, the amendments of Kampala have intent or have an attempt to build a new relationship between Security Council and the International Criminal Court, especially with the Office of the Prosecutor, because there is regulated there that when a prosecutor thinks that there is a basis enough to open an investigation for the crime of aggression, he or she has to notify to the Secretary General over this issue. Then the Security Council will have 6 months, a period of 6 months, to determine if the act of this issue is an act of aggression or not. if a Security Council makes this determination, okay, the Office of the Prosecutor can open the investigation. But if this period of 6 months conclude and the Security Council has not made this determination, also the jurisdiction of the court is activated. The Office of the Prosecutor can open the investigation with the authorization of the pretrial chamber. So I think that this is a new relation of the International Criminal Court with the Security Council. I think it's a very important issue. I also have to point out that as a potential judge and as a practitioner in the field of international crimes, I hope that this December, the jurisdiction of the International Criminal Court could be activated. It's necessary because all of the efforts of the International Criminal Court, and especially in this kind of crimes, are aimed to the efforts and to the peace ends. So this is the importance, and I think that we all are waiting to this activation of the jurisdiction of the court. Thank you very much.
Thank you, Ms. Ibáñez and Ms. Akane.
Thank you very much. I understand the crime of aggression is one of the 4 core crimes over which the ICC has a jurisdiction. And I understand that the facilitation process is going on in New York to gain the broad consensus on this issue. However, there are still divergent opinions and views on the court's exercise of the jurisdiction over the crime, especially regarding whether or not the court may exercise its jurisdiction with respect to the state party which has not ratified or accepted the Kampala amendments. I wish that the discussion on the issue will lead to common understanding and consensus on this issue among the state parties before they make any decision. Without the consensus on the scope of the court's jurisdiction on the crime of aggression, it might create confusion in the court practice. The world, this would severely damage the effective function of the court. But anyway, it is depending to the facilitation process and the ASP's decision. And if once activated, the implementation will be the hands of the judges. So in such case, as a potential judge of the ICC, I would trust to interpret the provision and to utilize in the actual cases. Thank you very much.
Thank you, Ms. Akane. I have a question over here. Thank you.
Merci. Je vais m'exprimer en français si les interprètes sont d'accord.
Thank you. I will speak in French. Thank you. I'm with Elise. I'm with the Coalition for the International Criminal Court. And I would like you to transmit a question to you, which came to us by way of Twitter, because we have invited the public to follow us. So I have a question from Henri, who sends his question from Burundi. Henri's question is, would you have any proposals so that the countries can no longer leave the Rome Statute and even to convince those that have not yet joined? Thank you, Henri, for your question.
And relates to how you as judicial candidates might approach the issue of states that have or may be considering withdrawing from the Rome Statute and also how to increase universality of the Rome Statute and therefore the system as a whole. If I can give the floor to Monsieur Vukoje to address this question. Merci.
Je sais, quelqu'un paye.
I know that some African countries are engaged in leaving the Rome Statute. I've read in the various publications the main reasons for this. But maybe it's a question of being selective, of the idea that the prosecutor is selective, and that the cases, the prosecutions are limited to Africans. I think that we must reject this reproach, because this question must be seen within the context of international criminal law. As you know, after the Second World War, we had the Nuremberg trials. These involved exclusively Europeans but also the crimes in former Yugoslavia also involved Europeans. As a judge, I also judged my fellow countrymen. I was the first judge in Bosnia Herzegovina to sentence someone, one of my fellow countrymen, for the crime of genocide. Because my profession is impartial. It is not always easy, but such is my duty. And this is why I think, with regard to this question, which is you're asking me at the moment, I think we must not forget the fact that the victims in these cases were Africans too, in the thousands. And the minimal demands of moral and of justice led us to judge the perpetrators of these awful crimes. Such is my answer. Thank you, Mr. Vukoje. Mrs. Akane.
This is closely related to the universality and sovereignty of the state. I understand. Last year, I attended the ASP, and I observed the discussion over the issues. And I thought at that time, the most important thing is to further discussion and to understand each other between the African, nations which expressed the dissatisfaction against the ICC's activities, and other nations and other state parties. And at that time, heated discussion was made in the plenary session. But after that, two of the African nations decided not to withdraw from the ICC structure right now. So I think first thing we should do is to develop our discussion and to connect each other. And in this sense, I am a candidate from Asian Pacific region. So it's not from Africa, not from European region. So I can be a bridge, in a sense, to connect different opinions countries as a judge to render our decisions or facilitate the discussions. And also, we have to make a respect of the sovereignty of each state party's decision. So at this time, I don't express my any opinions against the country which decided to withdraw or not to enter the Rome Statute system. But I try to say is that we have to continue to facilitate both opinions to connect. Thank you very much.
Thank you, Ms. Akane. Madame Alapini-Gansou.
Merci, Madame la modératrice.
Thank you, Mrs. Moderator. This question, which our friend Henri has asked, is a very pertinent topical question. When I see what is happening nowadays in the African countries that want to withdraw from the ICC, I understand that out of these 4 African states which announced that they wanted to withdraw, there are, I think, 3 states, South Africa, Burundi, and Gambia. So, yeah, 3 states. So out of these 3 states, there's only 1 which is still following this line, this logic of withdrawing from the ICC. So the question that is being asked here is to make suggestions so that countries don't withdraw from the Rome Statute, and that, even better, additional states join this statute so that we can try to arrange as best as possible this principle of universality. And so to speak about this question of withdrawal and of wanting to withdraw, yes, it's true that the question that's been asked is a question of the sovereignty of the state. And when a state decides to be part of a legal instrument of the size of the Statute of Rome, well, then the state has already somewhat decided to alienate part of this sovereignty. But it's true that when we speak about international criminal law and international criminal institutions, or even more generally speaking about human rights, well, states have never accepted to be put in the place of the accused. And I think that this is what's happening in Africa. And I consider this as something normal, which could occur also in other continents if similar problems were to be seen in those places. However, one must respect one's engagements. And so what can we do so that this type of situation not present itself? Well, I think that when the question of the withdrawal of certain states was raised, one of the things that was done is that we tried to explain that this issue is not necessarily linked to a specific continent. What I understand is that the responsibility for carrying on the dialogue between the ICC and the states, this responsibility is everyone's responsibility. To begin with the state parties, they really must understand the depth of the engagement with the ICC. The other thing I wanted to say is that the ICC is not necessarily here to beat on such or such a person. I think the ICC is strong because it is competent to judge individuals and not just anyone. And that is the whole problem. However, the states, they must really take their full responsibilities and they must see what's really important in the engagements they took for the Statute of Rome. I think what we have to take into account here is the human condition, human nature. This is what we're talking about here. We speak of the victims, and this is not a limited numbers. It's not a few victims we're talking about here. We talk about mass violations of human rights. We're talking about thousands of victims. And I can say this because when I was in the International Commission on the Violation of Human Rights in Ivory Coast, I can tell you that I really worked on hundreds and hundreds of corpses of children. This is what we're talking about. But there's also a role here for civil society, because I think that in this type of situation, when the state has failed, when the state is weakening, this is where civil society has work to do. They have to speak to them. They have to try to raise awareness in order to ensure that the Rome Statute continue to do its work. The other suggestion I would like to make is that we have to see whether we have to set up structures for reinforcing the capacity, in particular, of intellectuals in our countries. I'm thinking here about academics, about judges, magistrates, those who practice human rights on a daily basis and who can convince others. Because in our countries, our leaders are helped. They have advisors, and these advisors need to be reinforced in their work so that they can give good advice. Thank you.
Again, the withdrawals are an issue related to universality. The withdrawals of last year were a main setback towards the universality of Rome Statute. Besides, there are a significant number of states, 70, I think more or less, that are not part of the Rome Statute and have not concluded or have not included in the national legislations the core crimes or Rome Statute. Therefore, they not prosecute the core crimes. But The fight against impunity of those crimes under the jurisdiction of the ICC needs the ratification of all states. But what can we do about that? I don't have the answers. It is not a problem that can be solved only by the judges or only by the states parties, but it is a problem that has to be faced for all the actors in the international justice. The judges must have the work making better fairness and effective process, better decisions, better reasonings, better sentences. OTP, the Office of the OTP, must work also in this direction, making better investigations, quickly investigations. Also, civil society, I'm agree with this issue that Madame Gansou said. Civil society has a big obligation, moral obligation, to push the states to ratify Rome Statute. Because I have to say, since that the work of International Criminal Court and the international criminal law is aimed to achieve the peace. And the peace is a concern of the international community as a whole. So, therefore, the countries around the world, they should support this endeavor. In this issue, I think, complementing the other point of the question over the African question, I will say some things about. I don't think that ICC is targeting Africa. It's true. The ICC has a lot of cases coming from Africa, but it is because the born circumstances of the ICC. The cases were referred for the states themselves. There is only 3 cases, one that were not referred by the states themselves, one referred by the Security Council, and 2 where the OTP acted motu proprio. But it's also that it's also true that the International Criminal Court is perceived like that. And what can we do about? I think that a good issue is to work making the court more diverse. That's the reason, because the court needs diversity in the elections of the judge. Because the International Criminal Court needs another points of view, another perspectives, another vision. That's the reason, because it's very important, for instance, that judges coming from South America, from a very, very far countries as Peru, may be seated in the International Criminal Court, because International Criminal Court is working for globalization of international justice. And globalization is about all countries around the world, not only about one region. Finally, I could say that in this effort, the Peruvian experience and my professional experience can greatly contribute to this issue. And it will be a great honor for my country and for me to do it so. I am prepared. Thank you very much.
Thank you, Ms. Ibáñez. Et merci à tous les candidats d'avoir
Thank you, Mrs. Ibáñez, and thank you to all the candidates
participating in this panel discussion. Thank you for contributing to the transparent process of the elections of judges to the ICC. I'd once again like to thank the interpreters up in the booth up there for their efforts in helping all of us to follow this discussion, and to thank the Ministry of Foreign Affairs for hosting us in this room.